Well, welcome everybody, and a special welcome to any teachers or civil servants who are joining us from a chilly picket line. Tonight's lecture opens the 7th annual privacy course from UCL's Institute of Brand and Innovation Law. Before I introduce tonight's speaker, Cory Doctorow, I want to say a word or two about his co-author, Professor Rebecca Giblin. Rebecca is an ARC Future Fellow and Professor at Melbourne Law School, as well as the Director of the Intellectual Property Research Institute of Australia. Rebecca's work first came to my attention in 2017 via a collaboration with Professor Kimberly Weatherall from the University of Sydney Law School. The two of them had published a very smart book called What If We Could Reimagine Copyright? It contains some very sensible ideas and reframes the debate, proposing a fresh approach to the global protection of creative works. In Rebecca's collaboration with Cory on the book he'll talk to us about tonight, yet again, she demonstrates the depth of her legal insights. Together, Rebecca and Cory produced an excellent book. They present us with valuable insights. It's chilling, and in places, it's deeply depressing to see all those historical, legal, and technological sleights of hand set out in a single spot. A respected literary agent said to me last week she could only bear to read a chapter a day because the book made her so furious. It may be shocking to those outside the entertainment industries, but the abuses that Rebecca and Cory examine needed to be brought out into the light. I urge you all to buy it and read it. And I especially urge those in tonight's audience concerned with IP policy, competition law, and anyone concerned in the UK's shameful failure to implement Chapter 3 of the 2019 Digital Single Market Copyright Directive. That chapter sought valiantly, and for UK authors and performers, fruitlessly, to improve the rights and revenues of creators. Had it been introduced, it would have brought much needed transparency into their dealings with their contractual partners. And I hope that this book, Chokepoint Capitalism, will promote a shift in UK government policy in this respect. God knows the incomes of every creator could do with a huge leg up. So now to tonight's speaker. Cory Doctorow is known for his views on liberalising copyright, the use of Creative Commons licensing, and his criticisms of DRM. For a time, he was European Affairs Coordinator for the EFF, and he worked out of London, working to establish the Open Rights Group. He's also a visiting professor of computer science at the Open University, an institution that rewarded him with an honorary doctorate. He left the EFF to write full-time in 2006, returning as a special advisor in 2012. In Doctorow's first novel, Down and Out in the Magic Kingdom, it was published in what was to become characteristic of his releases. It was simultaneously released in print and in an electronic edition, the latter subject, one of the very first Creative Commons licenses. So tonight, on behalf of UCL's Institute of Brand and Innovation Law, I should like to extend a very warm welcome to you, Cory Doctorow, co-author of Chokepoint Capitalism.
Well, thank you very much, Amanda, and thank you all for joining tonight. As a recovering ex-Londoner, it's an enormous honor with a U to be here in front of you from my new digs in Los Angeles. I left London just ahead of Brexit and got here just in time for Trump. It's been a fun 7 or 8 years, and somewhere in the middle of there, I went to Australia to go out on a book tour with my novel Walkaway. And Rebecca Giblin, who was an old colleague of mine, one who I had really only had contact with electronically up until that point, we did an onstage event to talk about artists' rights, copyright, the sort of normal copyright wars stuff that we had both been embroiled in for decades. And as is often the case, this was an ultimately unsatisfying discussion, one that was generated more heat than light, and ended up being quite adversarial with people who were there to argue that the cause of artists' rights was identical to the cause of expanded copyright. And in the cab ride home, we got into quite a fierce discussion about how this fallacy plays out and how it has been a problem that, you know, and not just in the 2 decades that we'd been embroiled in the copyright wars, but in the 40 years since the sort of Thatcher Reagan era, there had been a monotonic expansion of copyright in every dimension. It lasts longer. It covers more works. The exemplary statutory damages are higher than they've ever been. And the ease with which you can secure those damages has only increased as well. And this has, in fact, produced an entertainment sector that is larger than it's ever been, and more profitable than it's ever been, both in real terms and proportionally. But again, in real terms and proportionally, the artists whose creative labor are the thing that these intermediaries in the creative industries take to market have seen their income fall. And that giving more copyright and more copyright and more copyright has not only failed to make artists richer, but it seems, at least at first blush, at least as a kind of good operating hypothesis, it seems to have produced dividends to intermediaries at the expense of creators. And so we set out to explore why. And the analogy that we settled on to as a kind of thumbnail sketch of what's going on here is that in a sector that is highly concentrated, right, in a sector where we have 5 giant publishers, 4 giant studios, 3 giant music labels that also own the 3 giant music publishers, 2 giant ad tech companies, and also 2 giant app companies. One of them is the same company, and one company that does almost all the ebook and audiobook selling in the world. That in that world, giving a creative worker more copyright is like giving a bullied kid extra lunch money. There isn't a threshold at which they get enough lunch money that they can eat. And that is true even, and I'd say especially, if some of the bullies who are taking that lunch money decide to divert it into an international campaign to feed the hungry school children of the world by giving them more lunch money. Still not going to get those kids fed. We need structural interventions to deal with structural problems. And so we set out to write this book. In particular, we set out to write this book to break what we saw as a deadlock between people who fancy themselves on team user and team creator, and more kind of importantly, they saw themselves as rooting for a proxy for either users or creators, where the proxy on one side would be tech companies who are notionally on the side of users, and on the other side it would be entertainment companies who are notionally on the side of entertainers. And spoiler alert here, if you've read George Orwell's Animal Farm, you know how this ends. The animals crowd around the farmhouse and they look from the pigs to the men and the men to the pigs, and they cannot tell the difference. It is a false binary to assume that there is one of these monopolistic titans who will brief for your interest if they emerge victorious from their mortal combat with the other kind of monopolistic titan. That we can do more than aspire to crumbs from the table of either the tech giants or the entertainment giants, depending on which one wins the current round of the long battle. And instead, we can demand that artists and creators be recognized as class allies, and that what's good for both of them is good for, or what's good for either of them is good for both of them, even if it comes to the detriment of the shareholders of both tech companies and entertainment companies. And I think the way to understand how tech companies and entertainment companies have become largely indistinguishable from each other and how they relate to artists, you have to understand some foundations of platform economics. Platforms are two-sided markets. They're widely understood as the kind of signature kind of business of the internet, where you have suppliers on one side, you have users on the other, and then you have a platform in the middle that at its best mediates between them in a way that's productive, and at its worst extracts rent from both of them. And platforms, I think, to the extent that they can control their relation to both of these groups of users, would rather extract rent from them than provide services to them, because the purpose of the platform is to provide dividends to the shareholders. The mechanism that it achieves that purpose might be to provide services to users and business customers, but that is all in service to the much more important goal, which is to make profits for investors. And so if you look at the life cycle of a platform, it goes through 3 very distinct stages. In the first stage, it takes whatever surpluses it has and allocates them to users as a means of tempting users in. So when you sign up for Facebook, if it's 2006 and they've just opened up the platform to people who don't have a .edu American University address, Facebook will tell you correctly, honestly, that they are the privacy forward alternative to MySpace, that they don't do any commercial surveillance. And moreover, what they're going to show you is what you ask to see. If you subscribe to the feeds of the people who matter to you, that's what you're going to see whenever you log into Facebook. If you sign up for YouTube, you get much the same experience, a minimum of surveillance, a maximum of the things that you ask to see. TikTok had a slightly different proposition when it first came out. It had this eerily good prediction algorithm, but it was an honest broker of that prediction algorithm, right? Once it determined what it thought you were going to like, it showed you that and nothing else. And so TikTok became this, depending on who you ask, either hypnotic or enthralling way to spend an hour or two every day. Amazon very famously operated at a loss. It took a loss on all of its shipping. It took a loss often on products and sold them below the cost that it paid for them. It took a loss by offering very generous returns policies that it ate out of its own shareholder capital. And all of that made for a good reason to show up and be a customer of those businesses. But all of this also locked those customers into those businesses. If you were a Facebook user, you were locked in by the collective action problem, right? You joined Facebook to hang out with the people who are already there. Other people joined to hang out with you. And if Facebook did something that was to all of your detriment, you might want to go, but the problem of deciding where to go and when to go would be so transcendently hard that you would just sort of linger there. Likewise, if you signed up for Amazon, you got ebooks and audiobooks at subsidized prices, but these were locked to Amazon's platform with digital rights management. And thanks to Article 6 of the Copyright Directive of 2002 and Section 1201 of the American Digital Millennium Copyright Act, it's illegal to remove that DRM even if you're authorized by the creator, which meant that every dollar or pound that you spent on electronic media from that platform was a dollar or a pound that you would have to forfeit if you deleted their apps and left the platform. And that was a way to impose a switching cost. Same with prepaying for Prime. It's well understood in retail research that people who prepay for a year's worth of shipping for pretty obvious reasons do all their shopping preferentially on the platform where they've already prepaid for that year's worth of shipping. So having now allocated surplus to users and having locked users in, business customers start to pile into the platform. And at first, the platforms are very kind to those users. So again, in the early years of Amazon, we heard a lot from people who are writing for Kindle or making Audible books for Amazon's self-serve platform about what generous terms they were getting, and in particular, how they were more generous than the terms that they had been getting with traditional publishers. Performers on YouTube found that if they made a video, YouTube would reliably show it to the people who'd subscribe to them. And indeed, if you were a media company who went onto Facebook, not only would your posts, which could be quite stingy, it could be just a few sentences from your article along with a link to view it on your own website, those posts would be reliably shown just not only to the people who subscribe to you, but also to people who never subscribe to you, to be shoved under the noses of thousands of people, millions of people, and turn into a funnel for generating traffic and people who are habituated to coming to your website. And for advertisers, Facebook offered a way to pay low fees and reach very large audiences. And as Facebook clawed back the surplus from users, it subjected them to kind of eye-watering amounts of surveillance, which it then turned into targeting services for advertisers that it marketed at rock-bottom prices. And so now you have the business customers of these platforms also being locked in. They are held hostage by the audiences who hold each other hostage. And once the lock-in has been accomplished on both sides, once there's lock-in among users who can't afford to leave, and once there's lock-in among business customers who are there because the users aren't leaving, then the platform can start allocating surplus to itself, to its shareholders. So, for example, TikTok was revealed last week by the newspaper Forbes to have a secret traffic generating tool they call their heating tool, where some appreciable fraction of the videos in your feed from TikTok aren't there because the algorithm thinks you like them. They're there because TikTok wants to convince someone to become a full-time TikTok creator. And so they take the videos that they have that they've posted, and they use the heating tool to just sort of shove them under the noses of millions of people who've come to trust TikTok's algorithm. They're taking surplus away from users and they're allocating it to performers. And they're doing it in secret. The performers don't know they're doing it. This is very important because it convinces performers that they were kind of secret prodigies of TikTok all along. That if only they had thought to try TikTok earlier, they would have seen that the algorithm just loves their stuff because TikTok is a site full of people who are there for what they're providing. This is not true. It's just that their videos have been shoved under lots of people's noses. Some of those people might like it. Many of them won't. But in any event, they'll end up with a bunch of subscribers. And once a lot of those people are locked in, well, then TikTok can dial down the service that they give them and do what Facebook does to the media companies who are currently there. If you're a media company on Facebook today, if you include an excerpt, it won't be shown to anyone. You have to put the full text of the article. And if you include a link back to your own website, it also won't be shown to people. It has to be Facebook only. It has to be a thing that doesn't direct people to leave the platform. And then if you want to reach the people who have subscribed to you, you generally have to pay to boost your post, to get into the feeds of people who want to, who've told Facebook they want to hear what you have to say. You have to pay Facebook separately. You can think of this as being similar to how Amazon's so-called ad business works. This $31 billion a year business is primarily composed of fees paid by vendors on Amazon's platform who bid against each other to be at the top of your search results. Searching for common products on Amazon can yield 5 screens, 50% of which are ads, which is to say payola, things that Amazon's showing you not because it thinks you like them, but because someone has paid them to see it. The thing that you searched for may not even appear in those first 5 screens. And of course, many of those items that aren't ads will be lookalike products that Amazon is selling after having observed its business customers' business and picked off the most profitable lines and cloned them, and then outcompeted them because it could preferentially return them as search results, and it could also sell them without enduring the fees that it extracts from other sellers. When you add up all those fees, Prime, shipping and fulfillment, refunding fees, and other platform fees like advertising, that's about 45%. These platforms also extract surpluses by imposing most favored nation clauses on their business customers. So they will often say that if you sell on our platform, you can't sell more cheaply anywhere else. This is the substance of the DC Attorney General's lawsuit against Amazon, because Amazon sellers who are paying 45% fees to Amazon don't have 45% margins to pay them out of, and so they raise their prices. And then because of the most favored nation status deal, they have to insist that those prices be matched at other sellers. So everything becomes more expensive because Amazon is more expensive. But other platforms do this too. Spotify tries to extract surpluses from its business customers with things like playlists. So if you subscribe to a playlist on Spotify, which is very easy to do, even inadvertently, because if you search for an album, you will often get a playlist that has the same name as the album, but which isn't composed of the same tracks that are on the album. It's composed of some of those tracks plus some things that Spotify has been paid to include. It can extract payola from its performers, and also things that Spotify has commissioned specifically from performers who are in a work made for hire arrangement and not entitled even to the pitiable royalties that Spotify pays. So a lot of these platform economic arrangements, these sort of dishonest platform economic arrangements, they are very complicated and performatively so. You know, there is a world of things that are hard to understand because they're complicated, but there's another kind of shadow world of things that are made complicated specifically so they'll be hard to understand. And the finance industry has a name for this, an acronym. It's MIGO, which stands for My Eyes Glaze Over. And it describes any kind of financial instrument that is so deliberately complexified that no one can figure out if it's any good. And just like the kid who finds a giant pile of I'm trying to think of a polite word for this, a giant pile of manure, and starts digging furiously in it because a pile that big has to have a pony under it. People are expected to get the thick prospectus and say anything this long must be honest, and therefore I'm gonna sink my money into it. And we spend the first half of this book unwinding some pretty Baroque Migo scams. And I'll give you an example here, which is Spotify, because Spotify really typifies this idea that when you look from the pigs to the men and the men to the pigs, you won't be able to tell the difference, that neither the tech companies nor the entertainment companies are in it for the artists or the audiences. They're in it for their shareholders. And while they may have disputed with one another about who shareholders should be benefiting, it was never really about audiences or creators. So Spotify, when it kicked off in the out of the ashes of the Napster era, it needed to take licenses from the big three record labels. There was no way it was going to repeat Napster's mistake of just trying to put the music online under some kind of fair dealing or fair use arrangement, or to move fast and break things and hope that the firms that controlled those rights would come to them and bargain once the service was a fait accompli. And so they approached the big three labels. There's three labels that control 70% of all the recorded music in the world and 65% of the sheet music, and that's Sony, Universal, and Warner. And importantly, these are not firms that invested in that music. These are firms that went on buying sprees, where they were able to acquire lots and lots of firms thanks to a profound shift in how we enforce antitrust law, competition law, where starting in the neoliberal era, we transition from the idea that we should stop corporate concentration because it makes firms ungovernable. It makes them so large that they can't be effectively regulated, irrespective of whether they are efficient or good. If they decide later on that they're not going to be efficient or good, that they're going to claw back some of those surpluses, if they're big enough, the government will be helpless before them. And I think anyone who lived through the spectacle over and over again of Starbucks and Costa and Amazon and so on not paying tax in the UK and being sought to be held to account, only to have lawmakers and regulators throw up their hands and say, we're just helpless against them. They can play the system better than we can understand the underlying logic of that harmful dominance standard that was at the core of antitrust and competition enforcement from the Gilded Age right up until the late 70s and early 80s. That was supplanted by something called the consumer welfare theory, which said that these firms, when they attain market concentration, they do so presumptively by being better than everyone else, and that to crush a firm that had merely because it had gotten big and cornered a market was to risk collapsing the benefit that the consumers were getting from their incredible efficiency and productivity. And so this consumer welfare standard held that mergers should only be blocked and should only be unwound, and competition should only be prohibited if it could be shown to be detrimental to consumer welfare. If you could show that somewhere at the margins prices were going up or quality was going down, and moreover that this was happening as a direct result of anti-competitive conditions and not because of shocks to wages or energy or other inputs, which in practice turned out to be impossible to show. And so you have firms that just went on buying sprees. They use their access to the capital market to corner whole markets to buy all of their competitors. This is true whether we're talking about the entertainment industry, but also whether we're talking about the tech industry. Google is a company that likes to brood itself about as an idea factory, but on that scale, Google's a pretty terrible failure. This is a company that has made one successful product, a very good search engine, half another successful product, a Hotmail clone called Gmail, and then everything else they made in-house crashed and burned. And everything they've done that's successful, their ad tech stack, their mobile stack, their server management tools, their video platform, all of it they bought from someone else in a merger that would have been prohibited prior to the Thatcher era, prior to the Reagan era. And this is true of the labels too. So Spotify went to Sony, Warner, and Universal, who owned all the labels that had invested in music, but had not themselves made that investment, and said, what's it going to take to get your music on our platform? And they said, well, that's simple. You're going to have to sell us large equity stakes in Spotify. We're going to become your business partners. And one of the reasons they were able to do this is that the copyrights that they'd acquired were extraordinarily long-lived. In the US, those commercial copyrights endured for 90 years after the date of their production, which in industrial terms is effectively immortal. To a first approximation, anything that's more than 90 years old is something that nobody's listening to. So if you have the 90-year copyright on those works, you have an effectively indefinite copyright on those works. And so they said, you're going to have to make us equity partners, and you're going to love this arrangement, because if we were acting as fiduciaries for the artists in our catalog, well, we would be bargaining as hard as possible for the highest per stream rate. We would want the distributional outcome to go Spotify last, labels first, because we're acting on behalf of our artists. But as co-owners of Spotify, we want you to have the best cost structure possible. And so we're going to negotiate a rock bottom fraction of a penny per stream rate that is going to be close to zero. Now, because we're very important commercial partners of yours, we do want minimum monthly guarantees. And so what that means as a practical matter is if you're Sony, you might be entitled to $20 million a month from Spotify, but because the per stream rate is so low, only 10 million of it can be attributed to any artist's streams. And so the other 10 million is unattributable revenue that you can give to some artists, no artists, one artist. You can use it as a heating tool to lure artists in. You can withdraw it later. You can give it to your shareholders. You can give it to your executives as bonuses. And then they struck another half of this bargain, which was to repeat this most favored nation status clause, which meant that the 30% of independent labels and musicians who weren't in the studio system were also getting these rock bottom prices per stream. And they didn't get these top-ups. They didn't get free advertising. They didn't get guaranteed minimum monthlies. They just got the infinitesimal fraction of a penny for every stream. And this meant that, they were able to structure a deal where when Spotify was on the eve of its IPO, their shares became worth a whole lot of money. Now, there's an interesting thing about that pre-IPO period with Spotify, because the deal that they struck with Spotify, the big three labels, was semi-coincidentally due to expire just before the IPO came. And obviously Spotify would not be able to do a public offering if it didn't have a deal in place with the big three labels. And so if the big three labels were acting as labels instead of as investors in an intermediary, they would have bargained then for a very big deal. If you're a neoclassical economist, envisioning a perfectly spherical cow on of uniform density on a frictionless surface in a mathematical model, this is the moment at which you would predict that Spotify would have to bargain away all of its surpluses to these key suppliers in order to have a successful IPO. But these suppliers don't want royalties. They want dividends. They want shares, because the royalties they have to tip out to their performers. The shares are theirs to do with as they will. And so they actually negotiated a discount on the eve of the IPO. And because, again, of that most favored nation status deal, all of the other labels who weren't in the big three cartel also had to give a discount to Spotify. So that's what Spotify looks like. You've doubtless heard all kinds of back and forth about whether Spotify gives artists a fair deal or not, but we rarely hear about all this complex, funny accounting that goes on in the background that produced this outcome, because it is a kind of eye-watering long story. And we have long stories like that about all kinds of platforms in the book, all of the major tech and entertainment platforms and how they run. But that's only in the first half of the book. The second half of the book, we give over to a very different project. We give it over to solutions. There's a kind of book that we were really sure we didn't want to write. It's called the Chapter 11 book. That's a book where you have 10 chapters of how terrible things are. And an 11th chapter, usually quite short, that says, let's all get out there and vote harder, shall we? We'll fix it. That wasn't our theory. Our theory was that these were systemic problems that did not have individual solutions, and that systemic problems require detailed technical systemic proposals whose theory of change is that because anything that can't go on forever will eventually stop, that we would eventually come to a crisis. In fact, the entertainment industry and the tech industry had been lurching from crisis to crisis for the whole time we'd been involved in this cause. And when those crises arose, that would be the moment at which these fringe ideas could move into the center. As sort of my arch enemy and indeed the architect of all of this nonsense, Milton Friedman, said when people asked him how his neoliberal ideas would become mainstream when he was such a fringe figure, He said, when crisis strikes, people will reach for ideas that are lying around. And that's how he went from being a crank to the court sorcerer to Helmut Kohl, Brian Mulroney, Augusto Pinochet, Margaret Thatcher, and Ronald Reagan, and how his ideas came to define the next 40 years of our economics, business, and law. And so that's what we're trying to do here. We are trying to develop technically detailed proposals for making real changes. And you're not going to find anything in here that you can do in your capacity as an individual. And indeed, we had an editor reject this book on the way who said, I just think people are going to be depressed when they read the second half and they realize that there's nothing that they can do as an individual. Can't you put in some individual solutions? And we were like, dude, you are so close to getting this, but you're not going to recycle your way out of climate change. And you're not going to shop your way out of monopoly capitalism. So I'm going to give you a couple of examples of how these things, how these solutions are structured, what kind of ideas we have in there. And then I'm going to wrap up by talking a little bit more of that theory of change. So one of the ideas that we have in there falls under the category of one weird trick. And it relates to something that Amanda mentioned in her introduction, which is Chapter 3 of the Digital Single Markets Directive and its transparency requirements. So if you are an artist whose work generates royalties, you are typically entitled to receive royalties and also to audit the accounting that leads to those royalty payments. And so when you audit those royalty statements, you will often find discrepancies. And we cite one source, a firm here in Los Angeles where I'm located, that has done tens of thousands of audits of record label royalty statements over the course of 3 decades. And for reasons that I cannot possibly begin to understand, in all of those instances except for one, the discrepancies were in the favor of the record label and not in the favor of the recording artist. Again, I have no theory to explain this. I can only assume that it's some kind of vexing, localized probability storm that makes life very hard for accountants who work at record labels. But nevertheless, when you find one of these discrepancies and say, sir, I believe you've stolen my money and I'd like you to give it to me now, they will say, oh, you musicians are adorable, but you can't do maths for toffee. You've got it wrong. You've made a mistake. You would have to sue us to get that money, which of course we know you can't do. But because we're such good-natured slobs, we don't want any hard feelings. I tell you what, we'll give you a discounted settlement. All you need to do is sign this non-disclosure agreement. So you can't tell anyone else how we're stealing from them, any similarly situated artist. Oh, and your accountant has to agree that they will never audit us again. Once you've successfully audited a record label, you're disqualified from auditing them again. It's a bit like the murderer having the forensics team show up and saying, gents, you can dig anywhere you'd like in my garden, just not in that one corner. I'm a little sentimental about that corner. I don't want you to mess up my nice freshly turned dirt there. And so this leads to rampant wage theft in record deals. And in other kinds of deals that generate royalties. And there's a simple fix for it. Because of the nature of monopolies, almost all of these contracts are settled in one of 4 states. And in the US, contract law is a creature of state law, and state law is significantly easier to amend than federal statutes or regulations. And so if in California, New York, Tennessee because of Nashville, or Washington State because of Amazon and the video game companies, or in more than one of them, if we were to alter their state law to say that as a matter of public policy, non-disclosure cannot be enforced when it pertains to material omissions or misstatements to the detriment of people owed royalties for creative labor, we would put more money in the pockets of more artists than 40 years of copyright term extension combined all over the world. This is a crack in the machine. If we stick a lever in it and wiggle it around, money will come pouring out of the machine and into the pockets of artists. If copyright term extension is the right to feel resentful of your audience for not reading your books in the right way, transparency on royalty statements is the right to put braces on your kids' teeth, groceries on your kitchen table, and a roof over your head. So this is the kind of right that matters. We do have some copyright related rights in our proposals. One is to extend and improve the termination rights that are embedded in some copyright systems. In the 1976 US Copyright Act, there was initial language that said that after 25 years, all copyrights would automatically terminate. All copyright assignments would automatically terminate. So if you'd signed over your copyright for the full term, it wouldn't matter. After 25 years, your publisher, your label, or your studio would have to come and bargain again. In most cases, they probably wouldn't bother. Rufus Pollock, who's an economist who used to be at Oxford, did a pretty important and well-received paper that showed that the commercial life of most copyrights is under 14 years, and at 28 years, which is he chose that because it was the original term of the U.S. copyright in the 1776 copyright. That after 28 years, it's really just rounding errors of works, and so the rights departments certainly know which works are still producing after 28 years. They can find those artists, and when they do, they can bargain with them anew for a better deal, because chances are, if you've got a work that's still producing revenue after 28 years, you negotiated that contract when you were quite young and new to your career, and you probably got a very bad deal. And so again, this is a way to change the material distributions for works that are successful, to change what share artists get from the works that they produce that generate revenue for their labels, studios, and publishers. In the US, what happened was the copyright termination clause was moved to 35 years, and from being automatic to being quite bureaucratically burdensome. And we have some technical proposals for streamlining the process and making it easier. Another way to improve this situation is to change the anti-circumvention rules, and I alluded to these earlier. Section 1201 of the Digital Millennium Copyright Act, Article 6 of the Copyright Directive, they make it a crime to remove digital rights management, even if you are doing so for a purpose that doesn't infringe copyright. In other words, it's somehow possible to infringe copyright or to violate copyright without infringing copyright, which I understand is just a hell of a sentence. And I'll say it again, you can violate copyright without infringing copyright. Moreover, under these anti-circumvention regimes, if you have an intermediary like Amazon that encumbers a work that they sell to your listener or reader with DRM, you as the creator cannot authorize that reader or listener to remove the DRM. Only Amazon can. And so this becomes a mechanism to lock you and them in. And when that lock-in is achieved, firms will naturally capitalize on it and claw back some of the surpluses from the business customers, from creators, to themselves. And in Amazon's case, that took the form of something called AudibleGate. Amazon has a self-serve audiobook platform called ACX. Creators who self-financed works to put on ACX, which they were highly incentivized to do, because in most genres, Audible's market share is in the range of 90%. They found that they had to accept very onerous terms. Among those was a 7-year exclusivity deal for Amazon. So even if you self-financed your work, you couldn't sell it anywhere but Amazon. And also that Amazon would offer a not well understood program to listeners who found that they didn't like the work. They could return it for a credit. So if you were a subscriber to Audible, and remember, those are the most important customers to get because they're locked in and they lure in business customers and they are unlikely to defect to a rival. If you were a subscriber to Audible, you got 1 credit every month. And when you were done listening to it, Audible would then really bombard you with messages inviting you to return it for a full refund, to get your credit back. You would get pop-up messages, you get emails, you get all kinds of reminders. You could return audiobooks that you'd listened to more than once, that you'd listened to 6 months ago, and just declare them to be unsatisfactory. And listeners, I think in unknowing innocence, went ahead and did that. What they didn't realize is that whenever a book was returned, the royalty was clawed back from the authors. The authors didn't really understand it either. They didn't understand it because Amazon did net accounting when it gave them their royalty statements. It said, you sold 5 copies this month. It didn't say that that represents 20 copies sold and 15 returned after we paid out of your pocket to make someone else's 1-book subscription into a 2-book subscription. When AudibleGate broke, and it broke because there was a data glitch that exposed 3 weeks worth of returns in one go, and the creators understood what was going on. Finally, a creator in Perth, Australia, called Susan May, set up the alarm with this and called it AudibleGate. A British forensic accountant turned mystery writer called Colleen Cross, who is also a creator on the ACX platform, decided that since there's never one ant, there's also never just one accounting trick. And so she went back and looked at how Audible described how it was paying royalties to ACX authors. And then she checked her own royalty statements and the other royalty statements that have been uploaded by authors who were trying to figure out what was going on. And she concluded that in many cases, Audible would claw back 2 royalties for every 1 return book, and that the way that they counted those royalties and collected them was in other ways unfair and inaccurate. And she estimated the total degree of wage theft in the hundreds of millions of dollars. That's something that Amazon disputes, but I believe her, and I believe her in part because Amazon hasn't shown us the data that holds up their end of the bargain. So Audible authors, they came together, they made a stink, and even though they were bound over to binding arbitration and couldn't seek legal redress as a class action, it was enough to shame Amazon into materially improving their circumstances. They now have dropped the 7-year exclusivity deal. They give better accounting, not just a net basis accounting, and so on. And solidarity really does get you somewhere. We talk about the Writers Guild in our book, who went on a 22-month strike against the 4 major agencies that had shifted the traditional split between agents and screenwriters from 10% for the agent and 90% for the writer to 90% for the agent and 10% for the writer. And all 7,000 writers fired every agent in Hollywood and ground out a 22-month strike and won an absolute total victory when all 4 agencies capitulated after 22 months. Solidarity can take you far. Taylor Swift, when she switched from Warner to Universal, used her bargaining power to force Universal to promise that whatever share of its dividends from selling off or its gains from selling off its shares in Spotify it gave to artists would be accounted for over and above whatever debts they notionally owed to Universal, and would instead just be cash payments. So when you record an album with Universal, you get an advance, and then charged to that account is also all the expenses associated with producing the album. You have to use their producer, you have to use their studio, you have to use their session musicians, you have to pay for the champagne at your launch, and all of that is counted to your account, and then you earn these pitiable royalties. The Beatles used to split 1 penny for every LP, but not the whole penny. They got 85% of the penny because 15% was deducted for marketing expenses, and then they paid their agent 10%, and then they split the remaining fractional penny among themselves. And so you can earn millions of dollars and still not have paid off hundreds of thousands of dollars in debt that you owe to your label. And so Taylor Swift said, look, if I'm going to come to Universal, then if you decide that these artists are going to get $10,000, it's not that you're going to mark down this ledger that you know they'll never reach zero on by $10,000. You will send them a check for $10,000. Solidarity is great. It takes you a long way, but it can take us further, because these are problems that are not unique to publishing, to the music industry, to film, to games. These are problems that cross all kinds of sectors. When we were on the planning session just before this call, when we were making sure that our sound all worked and so on, someone remarked that all 3 of us were wearing eyeglasses. Well, you likely wear eyeglasses too if you're exploring tertiary education and putting a lot of strain on your eyes. And what you may not know is that every pair of eyeglasses you're likely to find in any high street shop comes from one company, a European cartel or consortium called Luxottica Essilor, that not only owns every eyewear brand, whether that's Dolce & Gabbana or Bausch & Lomb or Coach or Oakley, they also probably own the high street retailer that you're in. They own Sunglass Hut, they own Lens Crafters, Target Optical, Sears Optical. They also make more than 50% of the world's optical lenses, and they also insure more eyes than anyone else. They own the largest eyewear insurer. They've raised the prices of glasses 1,000% in the last decade. All of the people involved in the eyewear industry, from people who have poor vision to people who make glasses and hope to make a living as an optometrist or a glasses maker, they are situated in ways that music fans and entertainers are situated, and they don't understand that they have the same problem that we do. But they can be made to understand it, as can everyone who's upset that 2 companies make all the beer, 2 companies make all the spirits, 3 companies do all the world shipping. There's 3 giant cartels that do all the world shipping, and for years regulators have been saying to them, hey, I know you get these great economies of scale from making the ships bigger, but isn't one of them eventually going to get stuck in the Suez Canal? To which they were told, sod off, you don't know anything about shipping, we do, and we think it's perfectly fine. Those people are also suffering under concentrated corporate power. That's true no matter what sector you're in. If you're a cheerleader, if you wear athletic shoes, if you're a professional wrestling fan. There were 30 professional wrestling leagues when I was a kid. There's one now. The sexually abusive billionaire Trump donor who owns it has reclassified or misclassified all the performers as contractors, taken away their medical insurance. They're all begging for pennies to die with dignity of their work-related injuries on GoFundMe. If you're upset about that, you're upset about the same thing that all of us are upset about, and you don't know it. So James Boyle, and this is how I'm going to end. James Boyle is a brilliant Scottish copyright scholar who now co-manages the Duke Center for the Public Domain in North Carolina with Jennifer Jenkins. And he's got a beautiful little potted history of the term ecology. And he says that before the term ecology came along, people didn't know they were on the same side. You know, some of us cared about owls, some of us cared about the ozone layer, but what do charismatic nocturnal avians have to do with the gaseous composition of the upper atmosphere? And it was only when the term ecology came along that these 1,000 issues became one movement. And there are 1,000 ways in which suppliers and users of services chafe at concentrated corporate power. Here in the United States, the healthcare industry is, you'll forgive the expression, patient zero for this problem. And once we realize that all these 1,000 issues are all connected to one another, that we all have the same cause, and we all have the same problem, then we will be able to form the kind of mass movement that will really make a change. That's where the solidarity will really kick in. So thank you very much for joining. I'm looking forward to your questions. I really appreciate it.
Oh, thank you very much. Audience, aren't you glad you came? Type a question that you might have in the Q&A section. I wanted to add a couple of music industry quirks, which drive me crazy. And anyone who knows me will know what I mean by the three little words. That in every publishing contract and in every record contract, you are accounted to only if the money is, and I quote, directly and identifiably attributable to your work. So baked into the whole system is a mechanism for appalling data and to be able to build a nice big fat la boîte noire, the black box. It makes it sound lovely if it's in French. The other bit I like is the advances system in a record contract, so that just as you have exploited and toured and marketed your second album, and the record company is about to start thinking about whether you might supply a third album, they exercise your option to deliver a third album. But in the period when you've been marketing and touring and promoting the second album, money has been generated around the world and it is coming into the country where you signed the contract. So before the accounting period where they have to pay you because you've recouped on the second album, they exercise the option, and therefore they beautifully lend you your own money, which you then have to recoup. It's just exquisite. I wish I'd thought of it, but I'm on the other side. Right. Evelyn Webster would like to know, did Amazon do something similar to the Audible refund scandal with ebooks?
Not to my knowledge. The ebook side, so on the Kindle side, they did agree around the time that the DOJ was investigating the price fixing arrangement with the big six publishers. They did agree to allow publishers to sell without DRM, and so that has given readers and publishers a lot more flexibility to offer works on other platforms without their audiences having to incur these high switching costs. What they have done, though, is really encouraged various kinds of authors, especially independent authors, to move into the Kindle Unlimited program, whose accounting is very opaque. And Kindle Unlimited, if you don't know, it's an all-you-can-eat program where you are, as an author, rewarded by some complex formula based on how people consume your works on the platform. And there are some good reasons why Amazon has had to change that. You know, immediately upon offering it, you know, and they said, well, the number of pages that people read is going to be the determinant of what you get. So authors, you know, people who are gaming the platform started unscrupulously doing things like putting a hyperlink in the book on page 1 that skipped to page 1000, which would then be interpreted as 1,000 pages of reading by the book. Or they had, word salad books that were just automatically generated, and then they used bots to read them, or they paid third parties or hacked accounts to get at them, and so on. So there's all of this opacity in the way that Amazon manages the billing, because they're in this adversarial relationship with scammers. But that adversarial relationship hides room for a lot of mischief. I mean, an analogy here would be to the war on terror, right? You can be legitimately worried about terrorists getting on airplanes, and also you can have sadists who work at the checkpoints who become kind of puny tyrants with their power and use it to humiliate and abuse people who are traveling. And you can have an absolute legitimate security goal and pursue it with no checks and balances. And the more opaque it is, the harder it is for people to understand, the more opportunity there is for that kind of mischief. And what I know now, that the Kindle Unlimited economics are very hard to understand. So what I know now is that every time Kindle Unlimited makes some noises like saying, "Oh, we're going to drop digital magazine subscriptions and force all the magazines into the Kindle Unlimited program, but we promise, double dog swear, that you're not going to lose any money," magazine publishers, the magazine publishers get very angry, and they do their own back of the envelope maths, and they say that this represents a huge transfer of value from us to Amazon. That the readers, even if the readers end up paying less, Amazon will still make more from them, because it becomes another way that those readers are locked to the platform, something else that they'll lose if they leave the platform.
Sahil Joshi wants to know, what are your thoughts on patents and their monopoly status?
Yeah, I mean, patents, it's interesting to be talking about so-called intellectual property in this context, because it's a term that's got a very funny and fraught recent history. The term intellectual property wasn't in wide use until the 70s. It was coined in the 30s, and there are examples of people calling things like literary property back to the Statute of Anne, but it wasn't widely used. When people spoke of these various regimes that we now lump together under intellectual property, they called them monopolies, right? Authors' monopolies, publishers' monopolies, and so on. And monopolies took on a pretty odious color. I don't know if they were ever held in great regard, but they certainly became quite odiously viewed. And certainly, if you were an industrial actor who wanted more of this kind of regulation that you were using to kind of manage the supply chain in your industry, and you went to Parliament or Congress and said, "My monopoly isn't large enough, please can you expand it?" You would look and sound quite sort of mustache twirlingly evil. And so what happened was, in the 70s, you had this industry body, the World Intellectual Property Organization, that set about changing the way that we spoke of these things, and in particular lumping them together, to lump together copyright, patent, trade secrecy, and today, like a wide range of other doctrines, not just trademark and trade dress, but also tortious interference with contract, non-compete, non-disclosure. All of these have become forms of intellectual property that get spoken of in the same breath. And the problem is that as a category, it's very incoherent, right? The notion behind patent is that if you disclose the working of a machine, then someone can make an equivalent machine that won't be covered by your patent. And so the state trades your disclosure for the right for third parties to make functionally equivalent machines that can also be used, and that can create competitive markets. So you get some hedge against competition, but not a total hedge, and it's time limited. Patent is not the same as copyright, and in the United States, we have copyright to uphold the useful arts and sciences. It says nothing about this quid pro quo for secrecy or what have you. It's a completely different regime. There is a really credible way of talking about that progress clause in the Constitution to say, if a copyright law does not promote the useful arts and sciences, right? If making some group of authors richer means that we get less authorship, then that's a bad copyright system. That's an unconstitutional copyright system under this progress clause. That's not the basis for patents, certainly not the basis for trade secrecy or trademark or any of these other rules. And so lumping them together allows for a kind of shell game where you can just say, All of these things are equivalent in some way, and what they really mean is this is my stuff, get off, or I'll have the bailiffs on you, right? And in copyright reform circles, the term intellectual property became a kind of anti-shibboleth, a thing that you weren't supposed to say, a forbidden word, because it was viewed as giving ground to your adversary, that you were admitting that it was property, you were admitting that all these things could be lumped together in some coherent way. And that really, if you were serious about studying so-called intellectual property, you wouldn't call it that, because a study of patents isn't going to tell you anything about trademarks. You have to study trademark for that, and they're, patent gives inventors limited monopolies in exchange for disclosure. Trademarks deputize firms to punish rivals that deceive their customers, and these are different frameworks entirely. But summer of 2020, I had a kind of revelation in which I realized that the vernacular use of the term IP, as used in commercial circles and legislative circles, did have a coherent definition, and it was this: IP is any law, regulation, or statute that I can use to reach beyond the wall of my firm and control the conduct of my competitors, my critics, or my customers. So anti-circumvention allows you to force your competitors not to build interoperable products, which allows you to force your customers to use the products in the way that they were designed. That's not a thing that historically has been in the domain of manufacturing. BMW is charging a subscription for the seat warmer in its new luxury sedan. Historically, you would have had the option to go to a mechanic who could just turn it on.
Yeah.
Even if BMW didn't want you to. And our policy response to BMW would have been, if you are so emotionally fragile that you can't bear the thought of people who buy cars treating them like they're their own property and modifying them as they see fit, you're in the wrong line of work. And we're certainly not going to go and tell them, or the mechanics that they patronize, how to run their businesses. And IP is the ability to control those two entities, right? The mechanic and the customer, and force them to arrange their affairs to benefit your shareholders. There's a guy, Jay Freeman, who built an alternative app store for the iPhone called Cydia. He calls this felony contempt of business model. And so, patent on its own, I think, is fine. I think that we can argue about what subject matter should and shouldn't be patentable. We could talk about non-practicing entities and patent trolling and how they're a drag on the real economy. We could talk about the problems of federalism in the United States and how you have Texas, which has become a kind of safe haven for patent trolls, in the same way that Ireland is a safe haven for tax dodgers. And federalism always has to contend with this problem, whether it's Cyprus selling golden passports to criminals, or Delaware selling financial secrecy to criminals. I mean, it's always a problem in federalism. But patent itself, just the idea that you're giving limited monopolies to inventors in exchange for disclosure for genuinely novel inventions that are not obvious to a skilled practitioner of the art, I mean, it's okay. We should use it where we see a dearth of investment, but the presumption that we should always use it, that it's not instrumental, but rather it's moral, I think is a mistake.
Now, we are actually running out of time. Sorry, Eddie, I'll tell him. He knows who I'm talking to. There's some really interesting questions, and what I'd like to do actually is convey them to Cory via an email, but we haven't actually got time to address all of them, and I really regret that, because of course, as you've talked, more and more have flooded in. How much time have we got, Lisa? Oh,
if you're happy to go for another 10 minutes.
I am.
That's fine.
Sure.
Okay. Well, I think Rafaela De Santis has said, what structural changes to copyright laws could be made that might benefit creators without having the unintended effect of also benefiting behemoth right holders? Has the horse bolted? Some of them are in your book, but you might want to touch on that, Cory.
Sure. There's this old joke from Ireland, not an Irish joke, but a joke from Ireland, whose punchline is, if you wanted to get there, I wouldn't start from here. So
Yes.
a tradable, alienable right, when you bargain among lots of SMEs, none of which dominate a market, is a productive way to enrich artists through market mechanisms. But under market concentration conditions, I think the horse has bolted, but that doesn't mean that we have to throw up our hands on rights that are sui generis to artists. So termination rights, transparency rights, doctrines of unconscionability and contract that specifically obtain to creative contracts, creating kind of public ownership of publicly produced works is a big one, so that creators have a common pool of works to work from. Blanket licenses, especially for older works that are statutorily managed, and where there's regulatory oversight through PROs that are themselves regulated for transparency, so that if you want to sample, you're not forced to sign a record contract, because 70% of all the music ever made is owned by 3 companies, so you can only get those sampling rights if you want to, if you bargain with them, and they're just going to take all of your sampling rights, which lets them crowd more people in. So instead we could create a statutory regime where there's a compulsory license, you pay your money, it goes into a third party, it's administered on behalf of the artist, not on behalf of the label. Creating common transnational rights databases. We have the most back-asswards rights database system imaginable today,
and mandated international labeling standards that you have to use.
Yeah.
I mean, that's a kind of basic one, isn't it?
Yeah, countries all, like, each PRO maintains its own database, and you have PROs that say, like, we've got all this money for this artist we can't seem to find. Her name is Beyonce. And since we can't find her, we're just going to treat this as like unattributable revenue and use it for new artist development, which turns out to be giving money to our friends.
Yeah, right? I found out £700 for M. Mozart in an unidentified fund in 1992.
That's great. So, like, if in the year of our Lord 2023 we can't figure out how to build a database, there is something wrong. So, like, let's build big transnational databases that are open and transparent, where anyone can look into them and say, oh wait, this person's cash is being flowed into that person's account, that shouldn't be happening, and can raise flags on it. As they say in the open source world, with enough eyeballs, all bugs are shallow. If we want to improve data quality, let's make it visible. I remember when Sound Exchange said, we're not going to tell you which artists we can't fund because we're worried that unscrupulous actors will go to artists and say, I know where there's some money for you, but I won't tell you where unless you cut me in for a share.
Yeah.
Not only is this surreal, like, there's an easy remedy for it, which is to really publicize which artists you have money for. And then that racket falls apart.
Yeah. Richard Fawcett asks, are there any examples you mentioned on the radar of the competition authorities in the EU? And do you see this more as a problem with copyright than competition law? My first instinct to that is it's not an either or. It's an across the board approach to all these problems that are shared across the whole range of the industry, and then not just the entertainment sector.
Yeah, I mean, I think copyright is downstream from competition in that, as I say, a bargainable, alienable right only works if you aren't outmatched by the other side of the bargaining. And so the anti-competitive concentration in the arts and tech sector mean that copyright is not particularly useful as a means of changing the distributional outcome of the arts markets. And so competition is a big one. And I think the European Competition Bureau is doing some very good work. The interoperability mandates in the Digital Markets Directive is a really big deal. And although I think that starting with end-to-end encrypted messaging is biting off more than they should have chewed. They should have started with social media. I still think there's a lot of room there. I think going after app stores is another one that's going to be very good. And there's a kind of made in Britain aspect to this that you might not be aware of. So the UK has the largest technical competition staff in the world. The digital markets unit at the Competition and Markets Authority has, I believe, 80 full-time engineers. And Parliament has never, although they allocated the fund to hire those people, never passed the secondary legislation to give them enforcement powers. And so what they do is write giant, stupendous, brilliantly researched market reports that they can't act on. But the European Union has an enormous suite of enforcement powers and no engineers. And so they pick up this ball and run with it. And so you have this kind of cross-channel cooperation, even post-Brexit, that is really making a lot of headway. It would be better if Parliament would give enforcement powers to these poor people down in Canary Wharf doing such brilliant work. But even without it, as we learned from Jurassic Park, life finds a way.
Oh, Cory, I think that's a really nice, optimistic note to end on. I said before everybody came on that I did also, I've got to share it with them, managed to find one joke in the book, and it's on the second to last page, where Cory and Rebecca say, if a corporation is a person, it's an immortal colony organism that treats human beings as inconvenient gut flora. Very true. Thank you very much. Cory will be appearing at a privacy course near you in the middle of March on the 5-week privacy course. He's giving the keynote where he's going to talk about surveillance capitalism and how we might be able to smash it. Thank you very much, everybody, for coming. And Cory, thank you so much for your time. And I look forward to seeing you when you're in London.
It was a real honor.
Take care. Bye-bye, everybody.